usually the corporate counsel is very familiar with the requirements in local law, and of course what we're doing normally is gathering documents and data, and a lot of that is internal communications, and interviewing witnesses who are, for the most part, employees of the company. And the challenge is that when we're talking to employees that are located in the group's offices in various countries, we have to be sensitive to the fact that there are a number of different legal regimes that impose some restrictions on what we can do and set the parameters for providing things like notice to the employees, and employment law, trade union agreements. It can be very different from one jurisdiction to another. Privacy and data protection law, and those things affect even the ways that we investigate from sitting at our desk or our home office. For example, the restrictions on monitoring employee emails and texts. In the United States, for example, there are only 2 states that even require prior notice of email surveillance, whereas in most of the countries around the world where there are strong labor laws or comprehensive data protection laws, there are requirements for advance notice of that kind of activity. And in some countries, it can't be a blanket surveillance, but it has to be focused on a particular investigation where there's a reasonable suspicion that there's already some activity in violation of law or policy, and in some cases that requires that there be some predicate in terms of notice. For example, in European Union and in countries in other jurisdictions around the world where there are laws that are modeled on the EU General Data Protection Regulation, it's not only not necessary, but really unacceptable to do that on the basis of employee consent. But instead, you would need to have an employee privacy notice of some kind that indicates in advance that there is surveillance of employee communications or the use of the employer's communications networks and information technology equipment for purposes such as monitoring for malware and for improper communications with competitors, or for using certain kinds of sites that could lead to security compromise of the systems, and for legitimate interests of the employer. And as long as there's that kind of notice, then you would have the basis as an information security staffer in the company, or as a corporate counsel, for being able to look into the use of the system and examine whether an employee was doing something improper. But without that kind of notice in advance, you could be in serious trouble for doing it. So there are some kinds of policies and notices that need to be in place in advance before you could even undertake some kinds of investigations within the company. So policies and procedures need to be in place that are in harmony with local laws and requirements, and even with trade union agreements. And that's the sort of thing that needs to be in a place ahead of time before you even think about individual investigations. More and more countries have whistleblower kinds of protections, and the company, of course, may have its own policies in order for its own protection concerning whistleblowers. Australia and New Zealand have protected disclosures acts for certain kinds of related activity. European Union has a whistleblower directive that's going to come into effect next year to try to harmonize the differing requirements across EU countries. UK probably won't put that directive into effect because it will be post-Brexit, but the UK already has some similar legislation. The US has Sarbanes-Oxley provision that requires companies that are listed on U.S. stock exchanges, whether they're U.S. companies or foreign companies, to have an anonymous reporting procedure for employees that become aware of accounting or auditing irregularities. And that's designed to protect the integrity of the market and protect investors in the market. But because of all these different kinds of rules in different countries, a lot of companies adopt reporting provisions for hotlines or websites, and they can use third parties that will set up these kinds of techniques for reporting various kinds of wrongdoing within a company, and they can cover a range of things. The Sarbanes-Oxley requirement in the U.S. is just for reporting accounting or auditing issues, but the EU requirement, which will apply to any company with 50 or more employees, whether they're publicly traded or not, it covers employees who want to report issues with money laundering, corporate taxation, data protection violations, public safety, environmental violations, and the individual countries can add to that list. FLI recently was helping a client that had operations in many countries around the world, and the third-party service that they set up with a website and hotline that employees could report into on an anonymous basis in the countries where that's allowed, and it's not allowed everywhere. They could report in not only those kinds of issues but also issues like potential violations of corrupt practices and anti-bribery acts, and sexual harassment or racial discrimination, theft of company property, any other kinds of issues that for one reason or another the employee did not feel comfortable reporting to their immediate supervisor. And that's actually becoming a fairly common practice in many global companies, because they feel that it helps protect the company from issues that might be becoming a big problem within the company, keeps them ahead of issues that they don't want to hear about in the media, or because of law enforcement or regulators knocking at their door, and issues that they're under a legal obligation to report to a regulator or law enforcement. Obviously, corporate counsel can be in sometimes a very difficult position, because corporate counsel needs to be aware of the kinds of issues that, for example, they are required to report upstream or required to report to law enforcement or to regulatory authorities, because if for example through either informally or through a whistleblowing program, if they are made aware of issues that either they personally or the company are obligated to report to public authorities, and then they don't do it, they may have just put themselves at risk or put their bosses at risk. They also have to handle these as I mentioned, even looking into the communications or files of employees, if they do so in a way that violates the company's own policy or the legal requirements for when they are allowed to look at private communications or conduct a disciplinary hearing without giving notice to the employees or allow them representation. In most of the countries, for example, with data privacy laws, they are allowed to conduct an investigation for some time before they notify the target in order to avoid compromising the investigation. But at some point they have to notify the target, or they have to conduct a disciplinary proceeding before they can take adverse action. And they have to work within the parameters of providing an opportunity to be heard, and without compromising the rights of other employees who may be involved. And that is usually controlled by the employment law and privacy law of the jurisdiction where that employee is located. So if this ends up in, if you're Australian corporate counsel and seated in Sydney, and this ends up involving an employee who's in Singapore, you really need to take advice as to what the requirements are in Singapore before you before you go too far in taking the action there, because you may get the company in trouble in Singapore. In terms of actually conducting an interview, for example, that needs to be done with some care. Some of your audience will have experience with that. Some of you will not. And sometimes your local human resources managers have a great deal of experience with it, and sometimes they do not. It depends on what their background happens to be. You need to take care not to give the impression that you are representing the interests of the employee that you're interviewing. If you do not, you need to be clear that you are representing the company. And sometimes that when you're dealing with officers, for example, with management, it needs to be done even with care there, because they may think of you as their lawyer when in fact you are representing the shareholders or the board. When I was in private practice with a law firm, we were sometimes hired to represent the board independently, and we would have to make that clear. And sometimes even in the conversation would come to the point where we would have to point out that the managers were free to bring their own counsel to the meeting if they chose, but they needed to know that we were there. We thought it was in everyone's interest to get the facts out on the table and to understand what they were, but we were there representing we were hired by the board and ultimately representing the shareholders, and that's they should be aware of that. What you don't want as corporate counsel is for an employee that you're interviewing to come back saying, yes, well, I thought you were my lawyer, because you can get into trouble with the bar, with the court, in a number of contexts, if it can be argued that you were misleading or misrepresenting. And when it comes down to those kinds of interviews with the person is at risk of being dismissed, or of being arguing that they were made the scapegoat, with the police or with the regulatory agency, you probably want to record that interview and ask for permission to do so. At the beginning of the investigation, you really don't know where it's going to lead, and sometimes it leads in unfortunate directions. In one case I was involved in, it turned out that it was the CEO who was sending sexually harassing emails to a subordinate. And the problem with the CEO is that everyone is a subordinate, and if you have the relationship or the dotted line relationship with someone who turns out to be involved, that can be pretty uncomfortable. So it's a good idea to get to have somebody else involved and to think about who the stakeholders are. If it's involving people in house, it's good if you can have somebody from human resources or the equivalent in your organization involved with you. It's often good not to be the only person in the room doing the interviewing. If there are two of you, it's often good in an interview context, or as I say, to record the interview. Occasionally I've had the interviewee ask if they could record the interview too, and with everybody having a smartphone these days, that can be a fair question, and you may be willing to accede to that as long as there are not trade secrets involved, and it may look suspicious if you don't agree to that. In some cases, you can take your time. If it's not if there are some time-sensitive issues, for example, if there is a security breach involving personal data, and you're required under local law to report that within 72 hours to a data protection authority, as is the case in many European jurisdictions, some Canadian jurisdictions, then you have to move very quickly, and it's often a good idea to bring in outside counsel or an outside forensics expert. Your internal information technology people may be very sensitive. They may feel that the finger is going to be pointed at them for having fouled up in some way, and you may need to take action immediately to prevent a further data leak. And if it involves, for example, payment card data, the forensics work may have to be done by someone who has a particular certification, a QSA certification, for example, and your internal people are unlikely to have that. And so you may want to have the work done by, if it involves a U.S. Breach, you probably want to have it done by outside counsel in the U.S., where they have broader privilege and work product doctrine protection, which doesn't really exist elsewhere in the world. And then the work can be done by inside and outside experts under their supervision and get the broader protection. So those are considerations that you could take into consideration when you're dealing with something like an IT security breach.